It was the worst decision of his career. Hi, I'm Scott Ott, and this is Bill Whittle Now. And Bill, I'm talking about former Supreme Court Justice John Paul Stevens, who served the court, the highest court in the United States of America, from 1975 until about 2010 when he retired. He's written a book, and that's been excerpted. Let's see if I can give proper credit, but in the Atlantic, in the form of a column, where former Associate Justice Stevens says that the worst decision of his career wasn't something that he did. It was something that the court did. It was the D.C. versus Heller decision, which upheld the individual right to keep and bear arms that many conservatives believe is enshrined in the Constitution, but the rest of us realize that it's merely for the formation of militias that was included in the Constitution. And Bill, that's actually his argument. His argument is, up until recent years, it was widely accepted that the only reason the Second Amendment exists is because we needed well-regulated militias, which is the preface to the Second Amendment. So, Bill, I know a lot of people have been over this ground again and again, and certainly nobody more than you. What I want you to do is kind of pretend that you're talking to somebody here who knows nothing about it, and kind of walk me through this process as to why Justice Stevens is wrong about D.C. versus Heller and his understanding of the Second Amendment.
Well, he may regret this as the decision he this may be the decision he regrets the most in the case of his time on the Supreme Court. But that tells me that he either can't read a declarative English sentence or chooses to disregard it just because he doesn't agree with it politically. There is no ambiguity about the Second Amendment. In fact, I did a firewall on this subject where we took a look at this discussion as it had happened with a linguist, a person who was expert in English and in the English that was spoken in the 1870s. And we took a look at this sentence because the sentence has caused a fair amount of confusion. The first thing I would point out to Justice Stevens is that the definition of a militia is a group of citizens who assemble and bring their own weapons. So where you would, if what he's trying to say is that the Constitution empowers the ownership of weapons for citizens in their own homes, specifically, and this is not the case, but if this is what he's saying is specifically for militia action.
That is correct. That's what he's saying.
Then what? So basically, what he's basically saying is, we just need to form more militias. Then, look, I'm not even going to get into that territory because it's not relevant. It is a very clear statement. It says that the establishment a well-regulated militia being beneficial to the survival of state. I missed that little bit there. The right of the people to keep and bear arms shall not be infringed. So what it's saying is essentially is that a well-regulated militia is one of the advantages that the right to bear arms provides. But it's not the only advantage, and it's not the reason that the people of the United States are free to defend themselves with firearms.
Well, he is saying, yes, that is the preface, and therefore everything else hangs on that. But he's also saying that if you look historically, people in colonial times, for example, were not loath to pass laws regulating firearms. In fact, Philadelphia, Boston, and New York all had regulations about discharging a firearm in the city before the Declaration of Independence actually was signed, or the Constitution. Philadelphia and other cities actually prohibited the storage of certain amounts of gunpowder. And so all of these he construes as regulation on firearms that would seem to be in breach of D.C. versus Heller's understanding.
He's just completely. I can't believe a person that sat on the Supreme Court is as stupid as that. So I'm just going to assume that he's basically just engaging in an awful lot of sophistry. So let's take a look at the laws that he determined predicated this idea that the founders never intended for the American people to own their own weapons. First of all, I'd be willing to bet you that if you were to go and do a survey of the houses of colonials during the time of the American Revolution, during the time of the signing Constitution, I think you'd be hard-pressed to find a house that did not have a weapon in it. I think you'd be very hard-pressed to find a house that did not have some kind of firearm in it at all times. So the whole thing is just nonsense. But let's just take a look at how much...
Well, he would likely agree with you on that, Bill.
Well, then, Well, then.
But he would say there was a purpose for that, and that at the federal level, anyway, the Constitution was saying that's why we are allowed to have
No,
guns.
that's because he cannot understand a simple English sentence. If the Constitution were to read the way that he wanted it to read, or the way he interprets it to read, it would say the people of the United States shall be entitled to keep and bear arms when engaged in the activities of a well-regulated militia. It would make the militia part of the requirements of the gun ownership, and it doesn't do that.
So you wouldn't be able to have a gun before you were entered into a militia, and once you left the militia, you would lose your right to have a gun.
Presumably, no, just the opposite. Presumably, according to Justice Stevens, all of the people in the entire United States at the time, most of whom owned firearms, would then have to turn them in or keep them in a lock closet to be used only in the event of a militia necessity. And that would have got the entire Constitution thrown out on its face, and rightfully so, because people weren't quite so stupid then. I want to come back to the two examples that he used, because I find them absolutely fascinating. So he's basically saying, well, the founders never meant for individual people to have their own weapons because Pennsylvania had a law against discharging firearms in the street. Well, I have weapons, and I think it should be against the law to go out and discharge firearms in the street. Does anybody think it's a good idea for you to walk through the streets of a town just firing off rounds in the air? Is that really his entire basis for this? Is that you shouldn't go outside and start shooting pistols in the air to celebrate the 4th of July or something?
So would you call that, Bill, a reasonable gun regulation?
I would call that a reasonable civic regulation, Scott. Look, gun ownership does not mean that you can do whatever the hell you want to with the gun. And no one who's a Second Amendment advocate pretends that it does. This is why it's a straw man argument. To say that, we all agree that the ability to just walk down the streets of a city and just start firing off rounds anywhere is against the law, is nuts. It's a perfectly reasonable law and says nothing about whether or not those guns should have been in the hands of the people in the first place. If the Philadelphia law had said what Stevens wanted it to say, the law would have said guns in the city of Philadelphia will be illegal and they will be confiscated. And if you were found in possession of a firearm, whether you fire it in the streets or not, you are a criminal under this statute and you go to jail. It doesn't say that.
Well, Stevens is not alone on this, Bill.
No, well, I don't care about that. I'm going to deal with Stevens' argument first. So Stevens is using a perfectly normal, absolute common sense regulation that anybody in the NRA would agree with as a reason for why the American people shouldn't arm themselves. Let's take the second example that he picked.
The storage of gunpowder in quantity in the city.
Yeah, the storage of gunpowder in quantity. Scott, gunpowder in quantity means 30 barrels of gunpowder.
Well, I don't know that that's what it was taken as. I'll see if I can get a specific amount here.
No. Gunpowder, did he say a specific amount?
Gunpowder law imposed a 10-pound fine on any person who took any loaded firearm into any dwelling, house, or barn within a town. So this is what I guess this is the regulation of storage of gunpowder. It doesn't say amount of gunpowder.
Okay, so what do you suppose, Scott? Just think about it. I'm just going to ask you to reach deep inside your mock progressive mindset here and use your imagination as much as you can and try to imagine, could there be any other reason why it would be in the interest of a municipality to prevent private citizens from owning large stockpiles of gunpowder?
Yes, I think that was because most of them were not yet in compliance with the city regulation that required sprinkler systems inside of houses.
Well, isn't that interesting? So what you're saying is, in an era where everything was lit by fireplace and candles, and most houses were made out of wood, and fires were endemic, burned down entire towns, that a municipality decided that keeping large amounts of gunpowder in the hands of private citizens, which may be kept in a tinderbox or a bamboo hatch or whatever they want to call it, certainly not safe in the bowels of a gigantic stone dungeon or armory of some kind. It doesn't say any gunpowder, and that's the point he's trying to make. It says large amounts of gunpowder. I happen to think that the reason that a city wouldn't want individual citizens...
And let me be fair about this. I inserted something that you're answering that is not in the story. So it doesn't say large amounts. It just says regulations regarding the storage of gunpowder. I don't want to misquote the story here.
Okay, the storage of gunpowder.
Yes.
Okay. Well, Scott,
But
again,
your assumption seems to be a sound one. I doubt they were
of
talking
course
about
it's
somebody having a small
it's a sound
quantity to
one.
go with the musket balls.
Of course it's a sound one. Gunpowder was stored and in armories, and you need a lot of gunpowder. I mean, you need a lot of gunpowder in order to do any kind of serious military work. It's not like you're just going to carry a little flask around. That little flask that you carried was one round. It was one round. So when they talk about storage of gunpowder, obviously they mean storage of quantities of gunpowder that might pose a significant threat to the public in the event of one of the many fires that happened all the time in this era of candles and fireplaces and wood houses. And that also seems to me to be an incredibly reasonable and normal kind of a thing for the city to pass. Now, here's the point that needs to be absolutely hammered. Okay? If an idiot like me can disarm these arguments in no time through the simple application of common sense, if it can be that easily dismantled, that if the laws that Justice Stevens was quoting in order to say that the founders never intended for the personal ownership of firearms, he wouldn't have to go so far into the weeds to misinterpret two perfectly common sense statutes in individual cities in order to support his argument. If he had an argument, he wouldn't have to go to that low level of evidence. And that tells me that he doesn't have an argument. And that tells me something much more important than that. That tells me that a man of his education, being forced to cite these two things as an example of his position, is fully aware. He's an attorney, for God's sakes. He's fully aware of how weak that argument is, which means that he knows that the argument is fallacious on its face. He just doesn't like it.
Well, Bill, the article was actually more than that paragraph. This isn't the only example he cites. Let's bring it up to more modern times. And basically, former Justice Stevens is saying that the idea that the Second Amendment is in place because of the need to have militias to defend states against, foreign and domestic enemies, it was uncontroversial for most of our history. He said there was the first two federal laws affecting the restriction of firearms was a 1927 act that was prohibiting the mail delivery through the Postal Service of handguns, and a 1934 act prohibiting the possession of sawed-off shotguns and machine guns. And these were enacted over minor Second Amendment objections, he said, that the vast majority of legislators participating in the debates dismissed out of hand. And so basically what he's saying is the Scalia court, if you want to call it that, during the term of Antonin Scalia, came up with an entirely novel way of looking at the Second Amendment that was controversial, would have been controversial in the 20s and 30s.
Okay. So now what's happened? His first argument is that it was constitutional, that the founders never, ever intended for the American people to be armed.
Except for the use of militias.
Except for the use of a militia. And I think we fairly well destroyed that idea by the fact that every single person in America had a firearm, but the militia argument is the one that has to be destroyed. So I'm looking for the actual wording of it in a type that I can read without my glasses here. Give me a second. Because the sentence is actually very clear. I know it causes confusion. Actually, I was going to say it causes confusion to people, but it doesn't cause confusion. They understand what it says too. They just don't like it.
I've got it here. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Okay. So what else is necessary to the establishment of a free state?
Oh, all sorts of things.
Like maybe the right to freedom of speech or religion or peaceable gathering.
I believe that was intended by the framers' bill to be free speech only in the context of militias.
No. Now, thank you. Yes. So if that statement says that a militia is something that's useful for a free people, what else is useful for a free people? And if you want to say that the right to freely speak my mind and the right to freely associate and petition the government, that doesn't mean that I have to be in a militia in order to have those rights. I don't need to be in a militia in order to have my Fifth Amendment rights. So now I understand progressives saying, aha, ha, ha. That's why they mentioned it in the Second Amendment to restrict it only to militias, but that's not what the sentence says. Look, the sentence is constructed in such a way as to say that a well-regulated militia is a benefit to America. Okay, we all good with that so far?
It's necessary to the security of a free state.
Okay. Why? We'll come back to that in a minute. It says, here's something that's desirable. And then it says, here is an ironclad statement that says, the right of the people to keep and bear arms shall not be infringed. It doesn't say, this is very important. The people who wrote this Constitution took enormous care with the words that they used. Never thought they'd be twisted like this. But if the Constitution were to be written with the intent that they claim, that the gun control people claim it was, they would have said that a well-regulated militia being necessary to the establishment of a free and fair state, all firearms shall be under the direct control of a militia, or individual citizens may not own firearms unless in part of a well-regulated militia, or a well-regulated militia is the only terms upon which citizens can carry weapons, or any of the other things that they claim it say. This is exactly the same as what they did with the Commerce Clause, and I'm going to use the Commerce Clause because it is an example of just how simple and clear a sentence is, and how hard you have to go, and how far you have to go, rather, in order to distort its meaning to make it mean exactly the opposite of what it means. The Commerce Clause is used by everybody to justify anything. They say that the Commerce Clause allows us to say that 1/6 of the nation's economy, the healthcare, is under the direct control of the Congress, and that all of the private businesses and all of the actions of the citizens of the United States of America regarding healthcare is under the direct control of the Congress because of the Commerce Clause. Well, as it turns out, there's an entire section of the Constitution that lists what the powers of the Congress is, and health care among the people is not among them. But the Commerce Clause is very interesting because the people who make this argument will say, well, this says right here, the Commerce Clause, the federal government shall be entitled to regulate commerce among the states. What they usually don't even put that in. The Congress shall be entitled to regulate commerce. Period. The Congress shall be entitled to regulate commerce. Period. That's where they leave it. And you go, wow, okay, I guess that does justify it. If you can regulate commerce, then Congress can do anything. You can make a case for anything. The spy cameras are part of commerce. So the Commerce Clause is clear, but the lies they tell about the Commerce Clause show you the same kind of lies they're telling about the Second Amendment. What the Commerce Clause actually says was, Congress shall have the ability to regulate. That doesn't mean control. It just means make even, make fair. Regulate commerce among the states, foreign nations, and the Indian tribes. So what that says is that Congress shall have the power to regulate commerce among the states, meaning that Alabama can't cut a deal with France. It's different than the deal that Minnesota wants to cut with France with regard to various exports. So if you as an individual are not a state or a foreign power or an Indian tribe, if you're not one of those three things, Congress has no business regulating anything you do. The things that Congress can do are clearly explained, and none of this is in there. So this piece of chicanery and this piece of legalese, it's not even legerdemain or anything. It's just plain lying. Is exactly what applies to the commerce to the Second Amendment. The Second Amendment has a qualified statement that says something like that. This would be a nice result, whatever, but, comma, the right of the people to keep and bear arms shall not be infringed. Period. And it does not say what he says it says, and he knows it, Scott.
Well, and he is not just
he's
not just saying, "Hi, I'm John Paul Stevens, and this is my opinion about this." He's actually citing the case that was precedent before the Heller case, otherwise known as the Miller case, that, in his words, unanimously concluded that the Second Amendment did not apply to the possession of a firearm that did not have, quote, and he's quoting from the case now, some relationship to the preservation or efficiency of a well-regulated militia. Now, we're going to have to take this down to the end here, and I want to do it with what he does at the end of his column. Former Justice Stevens basically says that this country now needs an amendment to the Constitution to overrule the Heller decision, and it desperately needs that to prevent tragedies such as the massacre of 20 grammar school children at Sandy Hook Elementary School on December 14th, 2012, from ever happening again.
Well, that's the only thing he said that he's actually factually correct on. Forget about whether I agree with him or not. That's actually the only thing he said that's factually correct on. Let me deal very, very quickly with this idea of prior rulings. We went through the progressive era in the late 1800s and early 1900s, and a number of constitutional amendments were added that actually reduced freedom of the American people. But to say that a court made a prior decision and therefore this trumps the Constitution is an argument I just don't buy. I don't care what the Supreme Court ruled in 1923. I don't care. It doesn't matter to me. You know why? You know why it doesn't matter to me? It doesn't matter to me because I'm an American citizen and I can read English. That's why it doesn't matter to me.
Well, he's not saying it trumps the Constitution.
No.
He's saying it affirms the Constitution.
No, he does not. What he's saying is that there have been Supreme Court rulings in the past that supported the restriction of gun ownership. And he's in agreement, and therefore, evidence of the fact that this is what it should be all the time. Now, I think it's been pretty clearly demonstrated here in the last few minutes that his argument about what the founders intended is absolute nonsense. So for him to fall back upon the idea that previous Supreme Courts have made this ruling is only to say that previous Supreme Courts also made the same kind of errors that he's making. And the reason that we have the kind of government we have and not being ruled by a priesthood is that the Constitution, the law of the United States was enormously meticulously prepared so that anybody who could read English could understand it. And if that didn't work, then you wouldn't have a system of government by, of, and for the people. I can read an English sentence. I can see the Commerce Clause says states, Indian tribes, and foreign nations. And his final point is the only point that he has that is actually legally correct. Yes, if the American people decide it's in their best interest to eliminate private ownership of firearms, you're going to have to amend the Second Amendment. You're going to have to pass an amendment abolishing the Second Amendment. You're going to have to pull 1/10 of the Bill of Rights out. Good luck with that. And the fact that Justice Stevens ends his argument with the only part of his argument that has any legal basis at all is an indication of how fallacious the first 90% of his argument is. The only ground he has to stand on at all is the ground that I don't like this amendment and I don't think it applies to the present day, and therefore it needs to be overturned because what the amendment says is crystal clear. It's crystal clear to anybody who has a fundamental grasp of English or logic or anything else. Advanced linguists have said that this is clearly the message, that this is an isolated dependent clause and this is the declarative clause. And on and on and on we go. And so this is the kind of example of why we don't need people like John Paul Stevens telling American citizens what they can or cannot do with their freedom. This is just simply the exact reason. And by the way, Justice Stevens, if you want to get into the Constitution, I'm happy to play a game with you here. The Supreme Court was never designed to overturn laws. It was not designed to overturn laws. The Supreme Court was designed to adjudicate the very highest level of disputes.
It is interesting how he phrases this, Bill, in line with what you're saying. He said, it's interesting how he phrases this at the end of his column, because he says an amendment that he has written in other contexts. He said that an amendment to the Constitution to overrule Heller is desperately needed. Now, if you're a justice of the Supreme Court, do you say we need to amend the Constitution to overrule a Supreme Court decision? Or do you say an amendment to the Constitution is needed to clarify the meaning of the Second Amendment?
I don't say either of those things. The meaning of the Second Amendment is crystal clear. What I say to people who use precedent is to say that just because a court in 1923 can't read an English sentence doesn't mean that we can't do it today. And much more importantly than this, the power of the Supreme Court to issue decisions on law is vested in them by the Constitution. Also included in the Constitution as the Bill of Rights is the simple declarative sentence. So the power of the Supreme Court to make a ruling in contravention of the Second Amendment is granted to them by the Constitution. And so if I have to pick which one of these two things I'm going to weigh more heavily, the Constitution itself or the interpretation of a bunch of snot-nosed Harvard graduates in 1923 regarding the Constitution, and whose entire power is granted by the Constitution, and whose decision is probably 40 pages long, I'm going to go with the single English declarative sentence of the law of the United States that makes the Supreme Court legitimate in the first place. It's a no-brainer for me. It's a no-brainer for me. Legal precedent is important as a function of law, but it is not by any means, it does not by any means surpass written instructions in the Constitution. And to say that the Commerce Clause empowers the United States federal government to tell a farmer what he can and cannot grow on his own land would have caused the founders to have they would have just had aneurysms over it. But this is a precedent, a legal precedent set by the Supreme Court, and it's commonly used in order to justify the power of the Congress to take whatever action they deem necessary and take whatever money they feel is necessary to do it, too. I don't buy it, Scott. I don't buy it. The Constitution empowers the entire discussion. It empowers the federal government. It empowers the Supreme Court. And if the Supreme Court makes a ruling that contravenes the Constitution, then that Supreme Court ruling is in error. And are you saying that you, just a simple American citizen with no legal training, are telling me that you know more about the Constitution than these 9 justices on the Supreme Court who ruled this in 1923? That's exactly what I'm saying. That is exactly precisely what I'm saying. I'm saying any citizen who can read English would come to that same decision.
Ladies and gentlemen, we have quite a few members at BillWhittle.com who made a decision at some point in the last several years to support BillWhittle.com and the production of these programs. And they have taken a stare decisis attitude toward that decision. They have let it stand. And we are glad for that precedent. We know they've also set an example for others to follow in that many of our members have encouraged others to join, and they are doing that even as we speak right now. If you'd like to be one of those people who joins this revolution of thought, and I say that only because this is one of the rare places in our society where we can actively engage the ideas of the opposition without straw man arguments, without talking points, just to pat ourselves on the back, without talking like we're in an echo chamber, just wanting to hear our own voices. We engage the opposition on their own territory, and we win with time-tested principles. If you're that kind of person, you like to do that, you like to foster that, go to BillWhittle.com and click that Become a Member link. For Bill Whittle, I'm Scott Ott. Thanks to the members for making this happen.